Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5125. Katherine J. Mera, Appellant versus Pamela Bondi. Mr. Swick for the appellant, Mr. Silverman for the appellee.
Good morning, Mr. Swick.
Good morning.
You may proceed when you're ready.
Thank you. We're here because the district court erred when it improperly applied the discrimination vel non, retaliation vel non stage of the case. In this case, Ms. Mera complained about disability discrimination and retaliation. Appellees responded that she was fired because she failed a PIP. And so the issue now is discrimination, retaliation, vel non. The district court kind of jumped to the conclusion that because she failed the PIP, there couldn't be any discrimination, retaliation. But that's not what the law is. And in the George versus Levitt case, the court makes clear, it's at 405 F3rd and page 415, the court makes clear that, well, really two things. One is that just because the reasons are true or not false doesn't mean there's not discrimination, retaliation. And on the other hand, as the appellee argues, even if the reasons aren't true, like the subjective feelings of the deciding official, what matters here. We would submit that it's clear that as of June of 2018, Ms. Mera didn't have performance problems. There was a mid-year evaluation done at that time. As a kind of a friendly back and forth. Ms. Mera thanking her supervisor, Darlene Johnson, and no indication that there's any unsatisfactory performance. At the same time, almost, there's a discrimination case pending regarding the accommodations that Ms. Mera requested. And there's a settlement of that also in June of 2018. And at that time, there's a written agreement comes forward from the settlement. And there's immediate pushback from the supervisor, Darlene Johnson, about how much accommodation and what the accommodation is going to be. And then there ends up being extended email back and forth, trying to work out what the accommodation is going to be. And it's not really until October 5th, 2018, that they finally come to a resolution of what the accommodations should be. Within days of that, there's like a series of hostile type actions towards Ms. Mera, beginning on October 12th, when there's an issue about her complaining about micromanaging. But more startlingly, what happens is I think it's on November 17th, more than a month and a half after the end of the performance period, Ms. Johnson issues a mid-year performance evaluation. I don't think that any juror looking at that is going to think, how do you get your mid-year evaluation 2 months, a month and a half after the period has ended completely? But that's what happened. And then, the evaluation gets put off for 6 months, and then no surprise that the evaluation, when it's finally done, May 16th, 2019, is unsatisfactory, which launches launches the PIP. And it's interesting, I think when the Civil Service Reform Act was first passed, the idea of a PIP genuinely was that supervisors would help their struggling subordinates to improve their performance. But I think that's a myth. And in practice, the performance improvement plan is just a precursor to a termination, which is what happened here. Now, if we look at it in the light of the performance improvement plan coming after the mid-year done after the close of the rating period and the performance appraisal done 6 months after the mid-year based on stuff outside the rating period, I think there's good reason to question some of the things that happened at PIP.
In order for us to reverse under our case law, we're performing de novo review, and we have to conclude, don't we, that the deciding official did not really honestly and reasonably believe the things that she wrote in upholding the termination recommendation, right? Isn't that our standard?
Sort of, but not completely. As far as the deciding official, Mary Powers, she essentially just rubber stamped what Ms. Johnson said.
But answer the question, as a legal matter, what do you believe you have to establish to convince us to reverse?
Well, also in the George versus Levy case, the court talks about if there's a subordinate official like Darlene Johnson that influences the deciding official, then there's a basis for discrimination or retaliation based upon that finding. I think that's at 405 F3rd.
I saw that. That's your kind of alternative backup argument, the cat's paw theory.
Yes.
But your primary theory, I mean, if you don't want to talk about the primary theory, that's fine. But I thought your primary theory was not cat's paw, but that just basically the decision didn't meet the framework. And I'm trying to get you to focus on why we should find that. Why is it that even if Ms. Powers honestly and reasonably believed what she wrote, nonetheless, there was enough evidence of pretext there to overcome that finding, or we should just not find that she honestly and reasonably believed what she wrote?
Well, if we take Ms. Powers at her word in the very first page of her decision, she says, I'm not going to address the discrimination and retaliation. And that's really the foundation for the defense, that there's discrimination and retaliation going on. And you have to look at the the charges by Ms. Johnson in light of the background of the discrimination and retaliation. I think that
you think that Ms. Powers should have said, well, because Ms. Mera is concerned about whether Johnson is discriminating and retaliating against her, I should kind of factor that in when I evaluate her performance?
Yes, in a way, because what Ms. Powers should do is say, okay, the employee here, Ms. Mera, is contending against the offering responses. The court kind of faults us because we responded to all that stuff, but offering responses to the charges against her. But the key to her thing is that her contention is that these are all motivated by discrimination and retaliation. You have to see that background when you look at the allegations, because you take, like, okay, one of the allegations is that Miss Mera, she did like 60 reviews, and Miss Johnson said she looked at 6 of them, found 3 or more errors in 3 of the 6 she looked at, and therefore she failed the PIP on that point. Okay, but if Miss Mera thinks these are minor errors and there were a few of them, that's her response. But the point is, if these are really serious errors, why didn't she look at the other?
But one of the difficulties is, the cases that govern are very clear that the court doesn't sit as a, super personnel department to reevaluate what we would have done had we been running the workplace. And that's where the standard that Judge Wilkins mentioned comes into play, that to overcome summary judgment, it's your burden to show a genuine factual dispute as to whether the deciding official, and here that's Powers, or even sort of combining with the cat's paw theory, Johnson and Powers, have you shown that the deciding official or officials didn't honestly and reasonably believe their reasons, their assessment that Ms. Mera did not successfully complete the PIP? And if they were honest and reasonable in coming to that conclusion, then it doesn't matter that Ms. Mera thinks, well, you should have evaluated it differently. And it seems like a lot of the argument in the briefing and in the response to the defendant's statement of material facts not in dispute is, no, that's her version, my version is different. And I think the question that we're asking here is, do you agree that that's not enough under the law for her to say, yeah, I get it that she thought that, but my version is different and my version is more persuasive? Is that the
When you say my version, you're speaking.
Mera is saying her version is more persuasive.
Well, it depends on which of the things you're talking about.
So let's say the red books, which the district court talked about in some detail.
Okay, the red books, Miss Mera had been doing red books for years, and her red books had always been satisfactory in the past. There was no change, no in the SOP or anything. She did the red books pretty much how she had always done them.
Now, the defense puts in evidence that there were content errors. I'm not sure I'm going to get the details correct, but a misstatement of an address or content errors. And the only response that Ms. Mera gave is there were style changes, people's styles differ. She never addresses the notion that there were actually substantive errors in those.
Well,
And she just sort of says like, oh, we had back and forth. But the employer is saying, for my purposes, multiple rounds of edits and changes on this body of work that she should know how to do. She's been doing it for 20 years. The employer says, I'm not satisfied with that. And I guess the question is, what is the evidence that Johnson saying and Powers affirming that's not satisfactory is, other than like tightening up the management, but is actually retaliatory? How do we infer that was not, that the intent was not a good faith evaluation of like, is this the way we want to get the work done, but was actually biased against Ms. Mera because of her EEO activity? What's the evidence that
I think the
what's
best
really
evidence,
going on?
the best evidence of that is the timing of the PIP, and the fact that the mid-year is done a month and a half after the end of the rating period, not at the mid-year of the rating, but a month and a half afterwards. And then there's an unsatisfactory performance 6 months following that. That I think is evidence that Miss Johnson had decided to fire Ms. Mera. And the PIP was just a matter of going through the motions. Now, the thing you mentioned about the address being wrong, that is a mistake, and it was corrected when it was caught. But the point of it is there's a standard working now that wasn't working for the last 10 years that, these books have to have every detail correct. And why has Ms. Johnson now adopted that standard and applied it to Ms. Mera under the circumstances? The reasonable inference is because she decided to fire her back in November of 2000.
But was there evidence that a different standard was being applied to Ms. Mera than was applied to other employees?
There's no evidence about that. The evidence is that a different standard was applied to Ms. Mera than had been applied in the past.
Right. And
So let's assume this is a hypothetical question. There's an employee that, everyone likes them, but they've been doing things wrong for 20 years. And then there's an edict from on high that we need to have everyone do everything correctly. And as a result, year 21, that employee is found to have made mistakes, and as a result is let go.
Well, I don't.
Is that discrimination or retaliation?
Well, it couldn't be retaliation unless you had other circumstances to show retaliation, protected activity. As far as discrimination goes, if it's a legitimate thing, if there really was an edict from on high, which we didn't have here, but just even a change in Ms. Johnson's viewpoint, then it should have showed up in the mid-year that was done in June of the actual rating period. And that's the purpose of the mid-year, is to give the employee a chance to correct things. Here, Ms. Mera was reluctant even to talk to Ms. Johnson about things because Ms. Johnson gets mad at her for asking her questions she thinks she should have the answer to. But the union, the collective bargaining agreement, you have to give notice during the mid-year if you're going to bring unsatisfactory performance. If at the end of the...
Was there a grievance on that point? If the collective bargaining agreement required the evaluation to be done by a certain point, is that something that would be subject to grievance?
Well, it was done by the point. They just did another one. It was done by the point, and then they just did another one after, 7.5 months later.
And the reason in the record that the employer gives for the delay was just wanting to cleanly separate the issue of the misuse of the government credit card and just resolve that. And it took some iterations, and there was the suspension was diminished, and then it was resolved. And they wanted to have that just dealt with before doing the evaluation. And I think the only thing I read in the record that Ms. Mera rebutted that as the legitimate non-retaliatory reason for the later timing was, well, that misconduct was separate from performance. They should have just done them both at the same time. They're separate tracks. That doesn't imply that it was bad faith, that it was a sort of part of a setup for retaliation for the employer to have decided otherwise. Let's just clear the air on this, and then we'll be able to separately and independently deal with the workplace issues. And you can question that subjectively, but I don't think we can question it without evidence that takes Ms. Mera's disagreement with that and it gives us a reason to think that she's pointed to something that actually shows retaliation.
You can say this is ridiculous, which it was. I mean,
Which is ridiculous. It's ridiculous to think that you should have the one out of the way before you do the other. Is that what's ridiculous?
Which one? They already did the mid-year.
Right, but to have the credit card,
The credit card was
Abuse.
resolved. She did her time.
resolved, and then after that, turn to the
What-
admittedly belatedly turn to the performance review.
One
Is
of
that
them,
what you were saying was
I'm
ridiculous?
saying one of them has nothing to do with the other.
I know, that's Mera's position, is that they're two separate things. One has to do with.
You don't have to be a
misconduct.
super personnel board to see that.
Well, no, because how the employer completes its tasks is part of how an employer runs an office. And I gather that some of the same people are involved in both, and it's taking a certain amount of interaction and probably, creating a certain amount of innovation on the part of supervisors. And to me, it seems not implausible that that's a good way to proceed, to sort of keep something that might make you feel negatively toward an employee, and just close the door on that
Well, the
before
door,
you get into evaluating.
the door was closed 6 months earlier when the punishment was, finally determined. So now it's time to do her evaluation. And where's the justification for doing a second mid-year when you're already done one? And that, I just think that that's inherently suspect, that it's like being, turning a blind eye to stuff, to things that are inherently suspect. To say that you can do the mid-year evaluation a month and a half after the end of the rating period. Mid-year is at the middle, not at the end. So I think that's.
And why, that may be not dotting your i's and crossing your t's as an employer. Why is it evidence of retaliation? Why is that the deficiency that it reflects, as opposed to just they weren't prioritizing it?
They'd already done it. Why'd they do another?
Right, but why is the reason, when you say this is inexplicable, why is the reason you fill in there?
Because
Rather than this is just, they're not prioritizing things that Ms. Mera might need, but that the reason they're not prioritizing it and they're not more prompt is because they're out to get her because she exercised her
Well-
EEO rights. That's what we as a court need to be able to point to.
because of the pushback that started in August of 2018, where Ms. Johnson is not approving. I can understand in a way. She probably wasn't involved in the actual settlement, but someone comes back and starts to live with, and she was not happy about it. And that's evident going back and forth. And then in the end, Ms. Mera pretty much gets her way. That's that.
But that is, accommodation is a process, and I understand that the decision was made what the accommodation would be, but then to implement it, the fact that there's communication about it is, in your view, enough to raise an inference of retaliation?
It's the fact that there's,
Communication by
dis-
Johnson saying,
I would say disagreement, but
even if, or disagreement, even if she's got remote work, what about these times when we tend to do things in person? Like if I ask that question as a supervisor, that itself raises an inference of retaliation?
no, but then if right after doing that, you decide to do the extraordinary thing of a mid-year evaluation a month and a half after the rating period's ended, there's something wrong there.
One of the, you mentioned that the main evidence of retaliation is the timing, that, was after
Yes.
Ms. Johnson was unhappy. And we do routinely recognize that at the prima facie stage. But when we're in summary judgment with the full record, our cases say that you have to have positive evidence beyond mere proximity to show that an employer had a retaliatory or discriminatory motive. And so I guess that's what this discussion has been. Can you identify what's the best evidence, 1, 2, or 3 pieces of evidence that are the best evidence beyond the mere proximity of Ms. Mera's EEO activity and the termination?
You're asking for the best evidence of a retaliatory motive.
Beyond mere proximity.
Well, the action itself is evidence of it. It's extraordinary that.
Which action are you
The
referring
action
to?
during the mid-year, a month and a half after the end of the rating period.
And how did that disadvantage Ms. Mera?
She had a relatively positive mid-year at the mid-year, and now she has a so-called mid-year where Ms. Johnson writes all these notes to herself. You know, that's.
Are you talking about the PIP? I'm not sure.
Yes, when
Okay.
she, yeah, in November 17th, I think the first PIP was in June. And then there's the email exchange on that, the actual PIP, I should say. And then the new PIP, the after the fact PIP, that's done on November 17th. The rating period ended September 30th. How can that be a PIP? I mean, how can that be a mid-year evaluation?
It's just a little bit delayed. It's a mid-year evaluation. It's evaluating conduct that was done in the first part of the year, but it's a bit delayed.
Not evaluating conduct, it's evaluating performance.
Performance, right. Conduct of in the job.
Right.
In the job.
And it replaces one that found no articulated performance problems that was done at the time it was supposed to be done. And it now comes up with them, you know, after the immediate experience of having this disagreement, dissatisfaction by Ms. Johnson with the accommodation being granted to Mera. Ms. Mera needed accommodation. I you know, sometimes think you tell clients, well, can you try to just try to live with it how it is? Because, you know, they're not going to like it if you push this. And, but she needed it. I couldn't, it's not something you could have told her.
Yeah. Other questions? All right, thank you.
Thank you
And
very much.
had you reserved rebuttal time?
1 minute.
All right. Even though we've taken you beyond your allotted time, we will give you the rebuttal.
Thank you.
Thank you. Mr. Silverman?
Good morning, Your Honors. Bradley Silverman for the Attorney General. This case began with a large number of discrimination and retaliation claims based on a number of different arguments, actions, but has narrowed to a single question: whether Ms. Mera's termination was retaliation for protected activity. Mary Powers, the deciding official, provided a detailed, reasonable explanation for her decision to remove Ms. Mera from federal service, and Ms. Mera fails to show a genuine issue as to whether that explanation was pretextual. Over the course of her 12-page memorandum, Ms. Powers reviewed the 13 HIP tasks that Mera needed to perform. She determined that Ms. Mera failed to adequately perform 7 of those 13 tasks. Importantly, she did not take issue with Mera's factual account of what happened. And she cut Mera several breaks along the way, such as, for example, not holding it against Mera that Mera did not attend the monitoring visit due to what Mera said was a medical issue. Ms. Mera's arguments that this amounted to pretext, generally speaking, fall into 2 broad buckets. First, she argues that her performance simply was satisfactory, but an employee's own assessment of her own performance is insufficient to give rise to a genuine issue as to pretext, as this court repeatedly has held. Second, she acknowledges at times that there were some areas where her performance falls short, but nonetheless said that it was good enough and says there were some extenuating circumstances and that this should not be deemed so bad as to justify firing her. But this court repeatedly has rejected exactly that kind of argument. At the end of the day, Ms. Mera's argument boils down to the contention that she should not have been fired, that her performance was good enough. Whether or not that's right or wrong, it does not suggest retaliation for protected activity.
Bracketing whether it does on this record, just as a matter of what the doctrine is, said that, you know, she contests and says her performance was satisfactory. If her performance was actually, I mean, you have to, as a plaintiff, get into the weeds a bit on those issues. If the employer says, you know, this, and this were wrong, and you as the employee, you know, of course the employer is the judge of what the employer wants. But if you as an employee can point out that the nitpicking was, you know, trivial in the extreme, and that your version is credible, doesn't have to be definitive at the summary judgment stage, but that somebody could agree that your version, I knocked myself out, I did as good as or better than I was doing in the past. You know, there were 2 spelling errors, and suddenly this was seen as, you know, a fireable level of performance. So clearly her account is relevant, right? Her disputes about whether or not she performed, that's relevant to a retaliation claim, no?
In theory, an employee's performance can be so plainly strong and the employer's accounts of her performance so plainly erroneous that the sheer mismatch between what is obvious from the record and what the the deciding official's decision says is so great that could suggest retaliation. That is why this court has required that an employer honestly and reasonably believe its stated reasons, because in theory, an employer's reason might be so unreasonable that just no one could really believe that that's what's happening here. But nothing like that happened in this case. Here, if you look at each of the 7 tasks that Powers determined Mera failed, Powers' explanations are reasonable. They're logical. And Mera, importantly, does not take issue with Powers' factual account of what happened. So just to return to the red booking example, this task provided that a single red book with more than 3 errors constitutes failure. Mera does not dispute that there was at least 1 red book with more than 3 errors. Instead, she argues, well, she really makes 2 arguments. One, she says these errors were stylistic in nature. But even putting aside the fact that her own assessment of her own work is insufficient to give rise to a genuine issue of pretext, the errors that Powers identified in the red books plainly went well beyond stylistic quibbles. These were serious substantive errors and omissions that an experienced grant program specialist should have known to avoid. Mera also argues that she received insufficient training on red books. Again, not disputing that there's at least 1 red book with more than 3 errors, which under the language of the task constitutes failure, but says she didn't have enough training. And Powers explains there are 2 problems with this argument. First, it is undisputed that Mera, in fact, was provided training in May 2019, which is 3 months before she was placed on the PIP. At JA, I believe 762, in her response to the government statement of undisputed material facts, Mera concedes that fact. So she did, in fact, receive training fairly recently before she was put on the PIP. But even zooming out and looking at the bigger picture, this is an employee who had been in this job for 20 years, generating red books, 9 of which were under Johnson's supervision specifically. So as Powers reasonably explained, this is someone who understood or should have understood what a red book required, and specifically understood what this particular supervisor, Ms. Johnson, expected of a red book. Now, whether or not Mera agrees or disagrees with that explanation, nothing about Ms. Powers' reasoning here is so bizarre or incredible as to give rise to an inference of pretext.
I take Mr. Swick's principal pushback on that Ms. Mera had a satisfactory job evaluation quite recently prior to the PIP. And so his inference that he would have us draw is she was doing the job okay. And it was frustration with her EO activity that pushed Johnson to tighten up the standard, find Mera deficient. And your best response to that is?
Well, this court in the Carpenter case has rejected virtually that exact argument. There, the plaintiff argued that she previously had received a 5 on a certain task, and her performance had not changed, and so therefore she has to have earned a 5 for this period as well. And this court rejected that argument because it presumes that performance does not change over time, and we know that's not true. Each performance period is judged independently from the previous one. So the fact that one's performance was adequate the last time doesn't necessarily mean that it's adequate this time. I would also note that the undisputed evidence in the record, Johnson testifies that she had in fact initially been planning to rate Mera as unsatisfactory for the 2016-17 period. But she decided to cut Mera a break, wipe the slate clean, because the misconduct inquiry had just ended. So Johnson decided to give Mera another chance, essentially, to clean all that up. And that is shown not only in Johnson's deposition testimony, but also her contemporaneous email at the time, JA 394. She's sending an email about Mera's then in the works 2016-17 performance evaluation, and she says that she's planning to rate Mera unsatisfactory. Now, we know that did not end up happening. I'm happy to take any questions the court has.
Thank you.
Thank you.
Mr. Swick, you don't have to give a rebuttal if you don't want to, but you have a minute if you'd like to.
Trying to think, I'll say 3 things in 1 minute. I think I'll just stick with one. The case that the council cited where an employee argues that they should be outstanding this year because they were outstanding last year, and this year they only got excellent. That really doesn't compare to saying, you were satisfactory last year, this year you're going to get fired. But the judgment is for the supervisor. It is for management to make what's satisfactory and what isn't. But in Miss Mera's view of her work isn't the key of it. What the key of it is her testimony about what the standard had been. And if the standard has changed, that something that used to be satisfactory is unsatisfactory and you're going to be fired. She's as competent as anybody else to say what standard she was held to the last time. And here, the standard did change. There's no edict from above or anything like that. There's going to be new standards.
But I have just one question on that. If an employer decides that it's been too sloppy in the supervision that it's doing, and it decides to be more demanding, then for an employee who suffers from that to show that it's retaliation against her, she would have to show that other employees were not, more was not similarly demanded of other employees, that it wasn't a genuine across the board, come on, let's pull up our socks, but something targeted at her because of her protected activity. And we don't have any comparator evidence in this case.
No, we don't, and this is not a case for comparator evidence. But what, under the scenario you're describing, where the employer says, you know, like the counsel said, well, I was thinking about giving her unsat last year. So, you know, this year I'm going to, well, then it should have showed up in the PIP. Or not the PIP, excuse me, I keep saying that. The mid-year. It should have showed up in the mid-year at the midpoint. You know, notice, look, you know, you're not cutting it here. You got to buck up.
It wasn't a glowing evaluation as I read it. It was quite, I mean, if you're reading that as an employee who has gotten better evaluation in the past, you would draw, or you could readily draw a message from that. This is borderline performance.
Well, I don't think so because of the tone. And you understand this isn't the email back and forth. That's not the mid-year. They talk.
No, I know, there's an actual.
There's
evaluation.
conversation, and Ms. Mera's email reflects that she came away with it like with a positive view.
All right. Any other questions?
Thank you.
Thank you very much. The case is submitted.
Case number 24-1007 et al. MSC Mediterranean Shipping Company SA petitioner versus Federal Maritime Commission and United States of America. Mr. Longstreth for the petitioner, Mr. Summers for the respondents, Mr. Reynolds for the intervener.
Morning, Your Honors. John Longstreth for petitioner MSC Mediterranean Shipping Company. I'd like to reserve 3 minutes for rebuttal. Federal Maritime Commission's grant of default judgment in this case was erroneous as a matter of law on numerous grounds. Most fundamentally, the Commission did not have jurisdiction over the case because each of the claims was directly and expressly premised on the assertion that MSC had failed to meet its contractual commitments. The Shipping Act removes the Commission's jurisdiction to hear such claims, even if they also state Shipping Act claims. The Commission recognized this in its Cargo 1 decision and said it cannot hear claims.
Where does it do that?
I'm sorry?
Where does it say that? Even if there are statutory complaints, jurisdiction is removed if arbitration is somehow available. Where does it say that?
So it says in 46 USC 40502F with the old
That's not what
8C.
F said.
I'm sorry?
F talks about.
It says
claims,
no jurisdiction over breach of contract claims. That's correct.
but it doesn't say anything about a situation where there are also statutory claims to be raised.
Right.
This commission clearly has jurisdiction under the statute. We've said it in at least 2 or 3 cases that the parties cannot negotiate that away.
Right.
There's no question about the law in this circuit on that. The commission's jurisdiction is clear to deal with cases in which the complaint is based on statutory misdeeds. And that's exactly what this is about. And they're clearly statutory misdeeds here. Whether you think they're meritorious or not is not the point. The point is that's something that can be litigated. The commission clearly has the authority to do it. And merely because there is the possibility of arbitration over some contract claims, it's not the question. And the commission made that clear in 1999. The commission decided the law 25 years ago.
Okay.
And I'm blown away by the argument you're making
Okay.
that, well, but 25 years ago, when
Okay.
you read Costco, it is absolutely clear what they're saying.
Right.
And no circuit court has ever overturned the commission's determination.
Well,
of its
okay,
authority.
okay, there's a lot there and
Yes, there
I
is.
understand where I'm starting. Uh, So three things I guess I would say about that. First of all, the issue has never been before a circuit court. That's correct.
Right.
It hasn't come up, and the cases very rarely get to this court. Second, I don't think it's correct to say that we're relying on the arbitration clause to somehow divest the commission of jurisdiction.
Oh, you
The statute.
pointed to F. That's your argument?
Yeah, but F, yes, but let's put it this way. F applies whether there's an arbitration clause or not. So I think the suggestion that somehow we're suggesting we have an agreement to divest the commission of jurisdiction. In this particular case, the
Hey, that's you
statute divests of jurisdiction.
Where?
Because the stat,
And you say.
it says it has no jurisdiction over breach of contract claims. And as the commission said in the case 25 years ago that you're pointing to, the Cargo One case, the commission very appropriately said that provision can't have any meaning unless some Shipping Act claims, which state Shipping Act claims, are nonetheless outside the commission's jurisdiction because of this provision. Because if it doesn't state a Shipping Act claim, then it doesn't state a Shipping Act claim. The commission doesn't have jurisdiction over it. The question, what the work that section is doing, the old 8C4, the work that is doing, and the commission was very explicit about this in Cargo One. We cite it, we quote it. They said there have to be some cases where you state a Shipping Act claim, but it's nonetheless jurisdiction is divested by 8C. Otherwise, 8C is meaningless. They don't have jurisdiction to start with. So there's got to be some category of claims, and that's what Cargo One said.
Let me just finish this.
Yeah.
Please. The commission said they looked at what you're suggesting and they understood that Vinmar could have been read that way, and they said there's a more nuanced way to read it. And if we're talking about situations where the claim is contractual, and that's all we're talking about, that's one situation. But where you have overlapping, where the commission said you have to be more sophisticated to look to see whether there are statutory claims here, the commission can rise. The fact that they could also arise in arbitration does not decide the issue.
That does not alone decide the
That does
issue.
not decide.
It does not
the
alone
issue.
decide the issue, but there is still an analysis that needs to be made under their law. And they said specifically, I think it's on page 14 or whatever the case we decided, I don't have it right in front of me, but they said absolutely specifically, we quoted it. You have to have some,
Costco?
I'm talking about the Cargo One case, the Cargo One Costco case.
We believe the more appropriate test, having gone through what you just said, they then say, but we believe the more appropriate test is whether a complaint's allegations are inherently a breach of contract claim or whether they also involve elements peculiar to the Shipping Act.
Right.
And if they also involve elements peculiar to the Shipping Act, the commission says, excuse me, they surely have jurisdiction if they want to assert.
Right, but the question is, are the claims premised on, and that's their exact language, and that's the language we think that they completely
Just read
ignored
the
here.
language.
Premised on,
Inherently a breach of contract claim.
right,
Or
and,
whether they
and,
also involve elements peculiar to the Shipping Act.
right, and then they go on to say in that case, and we quoted the language, if in fact the claims are premised on a breach of contract, and these are all premised on a breach of contract. You read through the complaint over and over and over again, they go back to the breach of
No,
contract.
you better read the whole page.
Yeah.
You're simply wrong, because that's not what they're saying. In contrast, where the alleged violation raises issues beyond contractual obligations, the
Mhm.
commission will likely presume, unless the facts as proven do not support such a claim, that the matter is appropriately before the agency. That's what they decided 25 years ago.
Right, and we
We
believe,
have said in at least a couple of cases, the mere fact that arbitration is possible does not divest the commission of its statutory authority. And this is a scheme that's well understood in ad law. The NLRB is a perfect example.
Right.
There are all kinds of contractual claims, and we've seen those fights over the years, where the board may not take authority, but they may have authority if there's an underlying unfair labor practice involved as well. That's what the commission cleaned up 25 years ago.
No, well, I'm sorry, I guess we're just disagreeing on this. And let me explain to you where I think the distinction is between what we're saying and what you're saying is. There is no question that we cannot divest the commission of its regulatory authority. So for example, it has regulatory authority over these contracts. And for example, the case that Judge Wilkins heard 2 weeks ago about detention and demurrage claims. There is no question that if a contract comes before the commission, and the question is this contract consistent with the Shipping Act or not consistent with the Shipping Act? In the detention and demurrage claims, for example, the question is, can you charge when they hold the equipment too long? And the commission is saying in that case, we don't care what the contract says. Your contract, in your words, Judge Edward, your contract cannot divest us of jurisdiction to determine what's reasonable, what's not reasonable. So we still have that regulatory authority, but that's not this case. This case is not saying there was something wrong with the contract. This case is saying over and over and over again, probably 20 times in the amended complaint, we failed to honor our service contracts
Let me ask you this
We
question.
failed to
Let me
provide,
ask you this question directly.
Yes.
Are you contending that if there are facts alleged that, if proven, could prove both a breach of contract and a violation of some provision of the Shipping Act, then necessarily that complaint fails the Cargo 1 test?
Not at all, Your Honor. And I think that's a very important distinction to make. You can have situations where there's an overlap, as Cargo 1 says. The question that's critical, we think, is do you have to prove a breach of contract in order to make the Shipping Act claim? In other words, does the commission, which is divested of jurisdiction to hear breach of contract claims under this section, okay, whether we have an arbitration clause or not, it's divested of that jurisdiction. It can't decide breach of contract claims. So then the question becomes, you've got a Shipping Act claim, and sure, they've stated Shipping Act claims, although their Shipping Act claims are basically, take their unreasonable practices claim. Their unreasonable practice claim is we had a practice of breaching our contract. Okay, their failure to comply with an agreement is, well, you had a service contract, you didn't comply with it. Every single one of their claims is absolutely premised on a breach of contract, and that's the distinction. Yes, maybe you can bring a breach of contract claim, you can bring a Shipping Act claim, but if the Shipping Act claim, and if you allege these extra factors that aren't premised, those extra factors have to be not premised on the breach of contract.
I start
Excuse
talking,
me,
you
yeah.
I'm
stop
sorry.
talking.
Sorry.
That's the way this works. Okay.
We don't get the big money, but we do get to speak when we.
I'm
want
very
to
sorry.
on the bench.
I'm very sorry.
So in count 1, what the ALJ found and what the FMC adopted as far as reasoning was that there was a systemic nature of the alleged violations that went beyond the typical breach of contract claim, because the alleged was failure to maintain or provide booking reports, systematically preferring higher price cargo and coercing surcharges, and that it also related to other shippers and not just MSC. So isn't that beyond proving just a breach of contract?
Well, in the Cargo 1 case, there were those allegations that there was an allocation scheme separate on the contract, and that's what's different in the Cargo 1 case, which is that in the Cargo 1 case, they did not come in and say these allocations violate the contract. Here, time and time again, they're saying the allegations violate the contract. And that is the basis of their claim, that we had the right under the contract to have this cargo carried. you, MSC, did not carry this cargo. Whereas in cargo one, they were talking about there should be some kind of reasonable allocation scheme under the Shipping Act. So that's what made that, in that case, a case that went beyond the breach of contract. Here, all the allegations, and they come back to it time and time again. They come back to it and say, here is a breach of contract. You failed on your service contract commitments. You conditioned compliance with it.
What
You know,
about-
it all the way through it.
Just to focus it
Sure.
on, for example, counts 3 and 4,
Right.
which assert unfair, unjustly discriminatory practice or undue or unreasonable advantage. And I understand you have a separate merits
We do.
defense on those. But just on the cargo one jurisdictional question, those obligations to conduct business in a way that is not unfair or unjust or not giving undue or unreasonable advantage, those are statutory overlays
Statutory claims.
on any contractual undertaking. And so is it your view that under cargo one, the commission lacks jurisdiction to hear those kinds of claims?
Our claim is that, yeah, that you have to look at what's being alleged, that this sort of, this broad brush notion that just because we have asserted discrimination, in other words, parroted the language of the statute, that's not enough, because you have to look at whether those claims are nonetheless inherently contractual. And they're inherently contractual if they're premised on a breach of contract. Their discrimination claim here is that you breached our contract and you may not have breached other contracts. That's their discrimination claim. And so our argument is that that, again, is, in the commission's words in cargo one, premised on a breach of contract, because that's what they're alleging. In other words,
But in that case, so let me back up.
Sure.
Stepping away from the particular allegations in this complaint, I assume that you would agree that under cargo one, it's possible for a carrier's conduct to violate the provisions barring discrimination or disadvantageous treatment, but not the service contract.
Yeah, it's possible for both to be the case. It's possible for it to.
Right. I'm just saying it's possible that you could have a claim under those provisions of the statute that didn't mention the contract, but was just about discrimination or disadvantageous treatment, right?
Yeah, you could certainly have allegations that did not depend on breach of contract, and those allegations could either be or not be a breach of contract. That was my answer to Judge Wilkins' question. I apologize again for talking over him, but that was my answer to Judge Wilkins' question, which is that if in fact you can make the Shipping Act claim without also proving a breach of contract claim, then it's clearly within the commission's jurisdiction, and there's all kinds of cases that will be in the jurisdiction. We're
But
talking
in
about the
some sense,
situation.
You're in those cases like this one, where part of the allegations does include facts amounting to breach, the breach becomes sort of a factual issue rather than like a legal fact, rather than the claim. The claim is the claim as outlined in
Statutory claim.
in the statute.
Right.
And cargo one, the only provision that cargo one really seems to kind of kick to the curb as outside of the commission's jurisdiction is there's that provision that is currently, I think it's 41104
A2.
A2A.
Yeah, A2A, yeah, failure to comply with
Which
a term of
basically
file
says
service
failure to
contract.
failure to comply with a service contract amounts to a violation of the act,
Right,
which is in tension with cargo one, because cargo one says, well, even though the commission has jurisdiction over violations of the act, it doesn't have jurisdiction.
right.
because
And that's a
of
good, example.
40502F over that claim. And I guess one question is, why don't we read cargo one as only resolving the apparent tension between those two provisions and leaving all the other statutory obligations subject to the commission's jurisdiction?
Okay, and Two questions on that. First of all, I think it's important to recognize in Cargo 1, the commission did not hold that those other provisions, the discrimination provision, and there was another provision, I can't remember, 6E or something, but we'll talk about the discrimination provisions. It did not hold that those discrimination provisions were in the commission's jurisdiction, even in the Cargo 1 case. It said they were presumptively in the commission's jurisdiction. Presumptively because unlike A2, which specifically says failure to comply with an agreement, in those cases, there are other provisions. But even there, when they sent it back to the administrative law judge in Cargo 1, the case settled after it was sent back, so they never got to that. They said, look, we're going to presume that these A2 claims, failure to comply with a contract, we're going to presume that those are in the jurisdiction. On those discrimination claims, we're going to presume they're not in the jurisdiction, but they did not specifically hold it. It was a presumption in both those
you have that
cases.
in reversed?
I think you missed.
Okay, I made up that the A2 claims we presume are outside the jurisdiction, the discrimination we presume are in the discrimination, and I must have misspoken because two people say I did. But anyway, so I think even in that case, it's important to recognize they did not say, even in Cargo 1, that just because you state a discrimination claim, you can't also have that claim ousted of jurisdiction because the
Really
breach of
didn't
contract.
speak to it either way, did it?
Well, it said it was a presumption, and I guess what we're saying in this case is in this case where you have a complaint that over and over and over again talks about failure to honor service contract. You know, look at the amended complaint paragraphs. It's a 129 to 154 of the joint appendix. You know, paragraphs 7 to 9. Failure to honor service contracts commitments, failure to provide space at contracted rate, conditioning compliant with currents. 19 to 21, all they're talking about is the service contracts. With respect to the service contracts and
So
negotiating service contracts.
Let's look at, I don't know if you have it in front of you, JA 147, where there's a list of allegations of respondents' unjust and unreasonable practices. So you're at like paragraph 96.
Okay, I've got it.
So like in paragraph 98, they allege that basically your client was demanding that several accounts have accepted this PSS pricing surcharge instead of performing under service contracts. And then, you know, similar allegation in paragraph 100. The way, help me understand this. The way I read your brief in your argument is that you say that that's still inherently a breach of contract claim because at part of it, the allegation is that instead of honoring our service contract with them, they're being forced to pay these other surcharges or ship under the spot market. And so it's still really inherently a breach of contract claim. Is that a fair articulation of your argument?
I think it is, Your Honor.
So what would be a case where someone rebuts this presumption under Cargo 1?
So
The one example you said is, well, if the contract itself violates the act, but there's got to be something more than that.
well, I mean, and I think this is a good example because I think this is a case where because of the nature of the allegations in this case. So when you're looking at paragraphs 98 to 100 on peak season surcharges, when you go back to the factual allegations in the complaint, which start at JA 139, 140, this is where they're talking about attempts to coerce extra contractual surcharges. You know, go to 51. They sought to induce complainant to agree to pay surcharges in order to obtain previously contracted space. 53, the service contracts do not permit respondent to hold or fail to withhold contracted space. 54, practice of failing to provide contracted space. So I think this is a case where the commission did say in Cargo 1 that we are going to presume these discrimination claims are within the commission's jurisdiction, but that presumption can be rebutted. It seems to me it's absolutely been rebutted in this case because those surcharge claims are all directly based on the allegation that we were breaching our contract in order to coerce these surcharges. So it does fall within that category of claims that Cargo One left open for 8C to do some work.
So my sense is that the proposition that Cargo One limits the commission's jurisdiction for statutory claims other than claims under A2A is a novel reading of Cargo One. Is there any decision that
No.
reflects that?
Well, there's and we pointed this out, there's the Global Link decision, which was a 2014 ALJ decision. And that's one that was a very similar case to this one, where the allegation was that the carrier had failed to carry a cargo under a minimum, it's an MQC, minimum quantity commitment. The case is Global Link. And what's interesting about it is, and by the way, this has come up very infrequently. There's some recent cases which we think suffered the same problem this does, that they don't really do the analysis required. But in the Global Link case, they specifically, the ALJ, and again, it didn't get up to the commission, specifically said that this is within 8C, this is within the jurisdictional limitation, dismissed the case. We cited that case to the ALJ. The ALJ ignored it. We cited that case to the commission. The commission ignored it. This is precedent on point. It's not commission precedent, but it's ALJ precedent. And finally, the commission on their brief said, well, this is different because there are a lot of allegations. We've got hundreds of pages. There's all this verbiage in there. But our view is that verbiage is time and time again dependent on a claim of breach of contract. And that's the analysis.
What does it mean? Cargo One says this, and the anchor shipping decision by the commission
Right.
says that, we read Cargo One, you boil it down, is we try to determine whether there are elements peculiar to the shipping act.
Mm-hmm.
That's how you know when the commission has jurisdiction, even if there's also breach of contract elements.
Mm-hmm.
Too. What do you think? How do we know that when we see it? An element peculiar to the shipping act?
I think, so there clearly has to be something more than breach of contract for the commission to have jurisdiction. I think that's what they're saying here. I think how we know it when we see it, is there a test? I think really in our view, are those peculiar elements premised on a breach of contract? Would they require the commission to decide a breach of contract claim that's been taken out of their jurisdiction by the act? And I think that's how you know it. And I think the premised upon language in Cargo One, we keep hanging our hat on that, and I think it's because it fits in well with this test. Are the claims, even if they allege these peculiar elements, are those peculiar elements dependent upon, premised upon showing a breach of contract?
In
And if that's the
Cargo
case.
One- In Cargo One, they also say, I'm sorry, Rob, go ahead.
Well, I just wanted to ask one follow-up.
Yeah, go ahead.
So you just heard us, observed us hearing an employment case.
Yes.
But just to use that like as an analogy as to why, I'm just trying to help you understand why I'm having a little problem with your test. So let's suppose you have an employee and there's an employment contract that says, your job duties are to perform these 10 tasks. And then we'll pay you, X dollars a year in salary. And even though the employee performs all 10 of those tasks, he's fired, but he also says, I was fired because of race or disability or
Sure.
some other protected activity. And there's a Title VII or ADA or some other sort of claim.
Mm-hmm.
To prove the discrimination, you're still going to prove the breach of contract, so to speak, in that, you said that, if I do these 10 things, then I'm a perfectly fine employee and I have evidence that I did those 10 things, but nonetheless, you fired me. It can't be the case that just because we would look at that and say, well, there's a contract there and prove the breach of contract, there's nothing really more there. There's no discrimination case there. I mean, there could be both based on the contract and the facts. And so I guess that's why I'm just having problems trying to figure out what cargo one and anchor shipping means in saying that something, and there's an element peculiar to the Shipping Act. And you say that the way that we are to find that is just, well, in order to prove the Shipping Act violation, they can't also rely on the fact that what was done violates the contract.
Well-
That's your bottom line?
I don't think exactly, Your Honor, because I think I understand your point and it's a good one. It is true, and I think Judge Pillard said this as well, that, that the facts that underlie the breach of contract might also be facts relevant to, a discrimination claim. But the question is, do you actually have to find a breach of contract? So for example, you could hold in your example, I think Judge Wilkins, that, based on these facts, it makes discrimination, makes out a discrimination claim. But, those facts can be considered, but you don't have to find a breach of contract. You can find a breach of contract, but you don't have to find a breach of contract in that case because it's a separate case. In this particular case,
But even in my hypothetical, wouldn't it be logical for the court to say, well, it seems to be evidence of discrimination that they're not even abiding by their contract?
Exactly. That's what we do in the NLRA all the time.
yeah,
It's common. And I wanted to add to my colleagues, I'd like to add this so you can weave it into your answer.
yeah.
In cargo one, you keep reading past the pages we've been focusing on. It says, on the other hand, we find the alleged violation involving unfair or unjustly discriminatory practices, undue unreasonable preferences, undue or unreasonable prejudice or disadvantage, and just and reasonable regulations and practices are inherently related to the Shipping Act prohibitions and therefore appropriately brought before the commission. There's no question about what the commission was saying in cargo one. There are situations where, like the ones that they list specifically, that clearly would involve the commission looking to see whether something is amiss in the way you were dealing with stuff under the contract to make the statutory determination. And they made it very clear they were retaining jurisdiction over these.
They did distinguish those, but as I will say, if you look at the order did in fact send it back to say, nonetheless, you could still have some circumstances.
Send it back for the commission to consider those.
Send it back for the ALJ to consider under
Right,
that
which
standard,
is,
yeah.
it was the commission sending it back to the ALJ. So the implication of that is, I take that to be opposite from the implication you're drawing, which is that they looked at those and said, the fact that there may be a contract
Right.
element or facts, embedded in that doesn't take it out from under our jurisdiction.
Not only that, they say they are inherently related to the Shipping Act's prohibition and are therefore appropriately brought before the commission. That's their whole.
Okay. Well, again, the order was a little bit different, but I take your point.
I have a sort of a question from the other side is about cargo one. So your premise is that cargo one is what we're applying, you're not questioning.
Yeah, our premise is that our premise is that they don't match cargo one. It's true that, particularly in the world we're living in now, that, this court doesn't necessarily have to accept cargo one. But again, we think if you read the premised upon a contract breach language in cargo one properly, this case falls well within it.
So a question that I have about cargo one is, I take it that under your interpretation of the commission's jurisdiction, there are no claims that arise under A2A, 41104A2A, which is a
Right.
provision that basically renders contract claims
Right.
statutory violations. In your
Right.
view, nothing under that provision is within
Oh,
the commission's.
oh, no, that's not true.
jurisdiction?
No, that's not true at all. Because when they talk about, so that's failure to, so the section is failure to comply with a agreement on file with the commission. So for example, that would cover unfiled agreements. And that's really it would cover,
Failure to comply with an Oh, I see.
under file. So in other words,
Not filed.
right, if it's not filed, so that there'd be that whole series of cases. And that provision really goes back to, it's sort of an anti-rebating, anti-rate discrimination provision. And remember, this all started when almost all carriage was under tariff, and even service contracts before the Act was amended in 98. That's the point of our merits based on count 3. Service contracts had to be filed and you had to offer the terms to everybody. So it was very much a tariff-based, non-discriminatory rate system. So 2A, really a lot of the work that 2A does is to prevent that non-discriminatory carriage in there. What the commission is saying in Cargo 1, though, is yes, there's that whole category of cases, but when the claim of a 2A violation is you did not comply with the terms of a contract that was filed with us, that becomes linguistically and logically almost indistinguishable from you breached your contract. You did not comply with a filed service contract. You breached the service contract. The overlap is, and I think that's what the
It just can't
commission
be
is
right
saying.
In light of the language I just read to you, that the commission states, if you're talking about unfair, unjustly discriminatory practices, undue or unreasonable preferences, undue or unreasonable prejudice or disadvantage, these are all emanating from the enforcement of the shipping of the contract. Nevertheless, the commission says it's within their authority.
Well,
These are claims.
Yeah.
I just read you that and you
Yeah, no,
nodded
we've
your
had-
head like, yeah, that's right.
No, we've had that discussion. We're talking about a different provision, though. We're talking about 2A. We're talking about the unfiled agreements. And that's a distinction that the
We're talking
commission.
about whether or not there are claims here. Please don't be impatient. We're the ones who have to decide it.
Sorry,
You
I'm
can
sorry.
be annoyed all you want, or you can just stop the case if you want. You want to be heard?
Yeah, I do.
Well, then you got to hear our questions. It's getting a little annoying,
Okay.
all these antics.
I'm sorry.
We're talking about whether or not there are claims here that should survive because they raise alleged Shipping Act violations. That's what we're talking about, including the most recent one, including the ones I just read to you at the end of Cargo 1, where the commission has answered what you're claiming and said you're wrong. These are claims that involve alleged Shipping Act violations, and they're appropriately brought before the commission.
Right. Yeah, no, I understand that. I thought we were talking about, though, A2, which in Cargo 1 itself had distinguished the A2 cases from the discrimination cases you're talking to. So again, I'm sorry, but I think it is a pretty clear distinction between those two, and I was trying to talk about A2.
So I have a question, just to shift gears a little bit about the discovery dispute.
Yeah.
Am I right that there was a certain amount of discovery material that you produced voluntarily in the case?
Yes.
And you're not suggesting, are you, that production violated Article 271?
No, that's the whole distinction. The distinction is whether it's production compelled by an order or production that was done voluntarily. And that was a distinction that we made very clearly. It's made in the Swiss legal opinions that were.
So in your view, would it allow you to sidestep the 271 jeopardy if you said, look, ALJ, I actually don't believe that you have authority or that I can respond to your order to compel, but I don't want to get hung up in that for years. I will voluntarily provide
Oh, will voluntarily
this
comply with the order.
information. information. I'm asking you not
Yeah.
to agree to that standing. here.
Okay.
I'm asking a hypothetical legal
Yeah.
question to probe the coherence of your position.
Sure.
And the question is, could you either before the ALJ entered this order or saying I resist that as a command, but as, counsel, I will recommend that my client voluntarily comply? Is that something that in your view would nonetheless leave you in jeopardy of criminal prosecution under 271?
That was our view, and that was the opinion that we got from our Swiss
That
counsel.
you could not voluntarily agree to give it, basically under protest? Say, we are not doing this because the court, the ALJ has asked us to do this.
Yeah.
We are doing this as a conciliatory effort to try to advance the resolution of this case.
Yeah. We would only be doing it because of we would only be doing that because of the commission's order. And so I don't, I guess the answer to the question is, I don't know if that specific hypothetical was presented to our Swiss counsel. It was not something that they volunteered. I mean, they felt that they had, let's put it this way. I think that would raise a question because the only reason we would be doing that would be because of the compulsion of the order. The Swiss counsel's
That's really up to you and your client.
Well, I just don't know what this, I don't know what the Swiss would say to that, because it seems to me it would be so obvious that the only reason we were doing that was because of the compulsion of the order, that it would raise, I think it just raises the same question.
Okay.
And again, there was a way to solve.
I
yeah,
hear you.
Yeah.
I hear you. You've sought advice and you got advice and
Yeah.
you think this would, if you couldn't, it wouldn't materially change the facts
Mhm.
on which that advice was premised to do what my hypothetical suggested.
Mhm.
Have you, at any point in the record in this litigation, it may be there, but I don't have it at my fingertips. Have you identified the specific types of documents, categories of documents, or information held in Switzerland that is particularly problematic
Yeah.
in terms of, I mean, the Swiss law, the business secrecy laws are there for
Right.
certain purposes, and obviously certain information is more sensitive against disclosure than other information.
Mhm.
Can you give us some sense of what the information is
Sure.
that you think would really alert criminal authorities?
Yeah, I think one thing that's very, probably most clearly within it is financial information. So they sought financial information, a wide variety of financial information about the business, profit, loss, that sort of thing.
About your client's business?
Our clients, yeah, and it's a privately held business. It's kept very confidential. And I think, as your Honor's question suggests, the Swiss tend to be pretty, sensitive about financial information. We didn't think that information was particularly relevant. As a matter of fact, on the amended complaint, we actually removed a defense that was cited by the judge to say that that information should be turned over. But that information is held in Switzerland, closely guarded. And we think that
Which of the discovery requests is that responsive to?
there's a discovery request where which of the defenses you mean? Because the discovery request asked for the financial information, and that was
the financial information. To be a little bit more granular.
it was profit and loss information, I think, was in there. I'd have to look back for the specifics. I've just thought about it.
All Mediterranean's profit and loss?
Yes, yeah, that's right. Yeah, their profit and loss for the whole year. And
For the whole world for the whole year.
Correct. And that's all held in Switzerland. That's very closely guarded. It's a privately held company. You can't find that information anywhere. And so.
What was your understanding of what the ALJ thought that was legally relevant to?
So the argument was made by our litigation opponent that that was relevant to a force majeure argument. And they never really explained, at least that I could tell, how it was relevant to that. But I suppose the argument was if we were arguing force majeure, we were arguing we couldn't do something. And the fact that we made a lot of money would kind of show that we could do that. I mean, that's you know, I guess that was the argument. It seemed like a little bit of a stretch. The judge at that point was, just basically said, well, they say it's relevant to force majeure. I say it's relevant to force majeure. She didn't really explain it, all that. So when they filed the amended complaint, we took the force majeure out of the case to try to resolve that issue because that's very, very sensitive information.
I have what I think is an easy question for you. That there's this back and forth in the briefing about the Hague Convention versus the intergovernmental consultation
Right,
process
exactly.
under the statute. You don't dispute that the Hague Convention is an acceptable substitute for the statutory intergovernmental.
Absolutely. That was our argument all along.
Right. Well, you appeared to suddenly argue that that the statutory process is obligatory, and you have, as you said, argued all along that the Hague Convention process.
Right, that would be a substitute
Okay,
for it,
fine.
yes.
Did you seek at any time to appeal the Geneva court's determination? Is there an appeal available from that?
We were told that it was not because it didn't really order us to do anything. In other words, there was no compulsion from the Geneva court's ruling. It didn't order us to turn over any documents. It just said Hague was not available.
But it
So-
it denied you the relief you wanted, which is
Yeah,
to
but
say
it-
so under Swiss law, that's not an appealable order?
That was, again, that was the advice we got from Swiss counsel, that the best way to handle it would be to fix it with the, and I'm trying not to use fix it in the sense, the administrative law judge kind of thought we went around the court and all, but basically to have the problem resolved by the Federal Office of Justice and the Swiss Minister of Justice. And ultimately, we were successful in doing that. It's just at that point, it was too late and the administrative law judge had moved on and decided that she didn't want to spend any more time on the Hague Convention.
So your position is not that it's not appealable, but that the strategy decision recommended
No, I
to
think
you by Swiss counsel was that you'd be better off going to the executive.
No, I'm sorry if I suggested that. I didn't mean to. The suggestion we had from them was that it wasn't in fact appealable because they had not ordered us to do anything. The trial court, the court of first instance, had not ordered us to do anything. They had just said these provisions were unavailable. And so there, and again, going back to it, the Swiss counsel had said that really this request should have been directed to the Federal Office of Justice to start with. And that basically if we had done that, if that had been done to start with, we wouldn't have had this erroneous answer. And so the better thing to do was to do that. But I do think there was, and I don't think, I'm being a little cautious because I don't think this was stated in written advice from them. But my understanding was that this was a preferred course of action, not only because it would work, which in fact it did, ultimately did, but that because there was a question about appealability of the ruling. And then also appealability of the ruling, again, would have taken, appeals take time. And Swiss counsel said this could be resolved quite quickly if we went back to the Federal Office of Justice, which we did. So,
I just have a couple more questions.
sure.
You argue that the default judgment was abuse of discretion. And I guess I'm curious more particularly where you thought the ALJ crossed over from making rulings that you disagree with to
Sure.
abusing
Sure.
her discretion.
Well, two things. Well, first of all, in addition to abuse of discretion, we thought it was a legal error because the consultations, which were statutorily required, weren't conducted properly. And that both sides agreed after the Swiss trial court came back, both sides agreed that consultation should go forward. It was the judge herself, sua sponte, who decided that she wasn't going to do that. So I think that itself was I mean, a legal error or an abuse of discretion, it's kind of the same thing. But then I think also it was an abuse of discretion because there really wasn't any effort to look at the discovery we'd provided, how that related to the case, issues in the case. There was a listing of the information we didn't provide, which of course included, for example, this financial information, which was, we thought, no longer relevant because we'd removed the defense that required
Was
that to
was
be
there
provided.
no other information in that list that you thought was relevant?
I'm
No,
sorry.
you've argued that you didn't think any of the information.
Well, that's why we opposed the
any of
motion.
the first-
Well, that's why we opposed the motion to compel, yes.
And was all of it information that would violate secrecy law, or is it just more the procedural thing
Yeah,
that you have to get Swiss authorities on board if you're
Right.
if any of the information, even if it's your own information, is divulged?
The act of production. The act of production, ordering that production from Switzerland, would be considered a violation of Swiss law under the advice that we got. Yes, because we'd be,
So the ALJ abused her discretion in not going a second time through a Hague Convention request. What if the second one was denied? Would she abuse her discretion in not going through it a third time?
well, I mean, I think there would be I can understand that. I think our point is, if in fact it had been denied, there does need to be some process. I guess if it had been, I guess it would depend on the grounds in which it was denied. Because if it were denied on the grounds, and this was an error that the commission made, by the way, in discussing what had happened in Switzerland. If it had been denied on the grounds that it was unnecessary and that it was okay for us to produce the documents, then of course we would have produced the documents, wouldn't have had to go through it again. One of the problems we had here is when that request was denied, the commission said, well, because the request was denied, that means further consultations are unnecessary. And that wasn't the case at all. Because the request was denied, it meant we didn't have the protections we needed under 271, and therefore some other means of consultation was required, and the other side agreed on that. So I think that was just an error by the commission. Again, I don't know if we call it an error of law, abuse of discretion, but they basically held that, well, we had no reason left to withhold that information because they'd held that the consultations were unnecessary. That's not at all the case. They said the Hague, to go back to your example about how we considered the Hague to be a substitute for consultation. If Hague had been a substitute for consultation, that would have been fine. We could have gone ahead. Once Hague was not a substitute for consultation, then we had to once Hague was not a substitute for consultation, then we had to have some other basis for it. So, and actually the way you know the commission was wrong, that the consultations were not unnecessary, is we went back, our Swiss counsel went back, and in addition to asking for the Hague procedures, they said, can we get a waiver? Can we get a waiver of 271?
Right, and they said no.
And they said no, because Hague's available.
So basically, it's your view that, this is a little bit more nuanced than what I gleaned from your brief. You're saying that had the Geneva court ruled, not that the commission, the administrative proceeding is not covered by Hague, which is what it did find, but that you don't need it.
Right.
And that would match up better with the potential exposure under 271.
Sure.
And that's why you're now arguing about the statutory consultation requirement, because you're pointing that the Geneva court's order is sort of neither here nor there, it can't fulfill the consultation requirement.
Correct.
It didn't give you a yes or no answer on the
Correct.
question that the statute is anticipating be answered. I think that answers my final question to you right now, which is, how do we decide when an ALJ or a district court judge has to disregard a ruling of a foreign court based on contrary legal conclusions from that country's executive branch or private legal experts? Like, how do we, sitting here in Washington, D.C., and not, having Swiss lawyers at our elbow, figure that out?
I guess we have two answers to that question. First of all, I don't think you have to in this case, because I think in this case, nobody had to decide nobody had to decide who was right. We had a situation where we felt we needed the protections of the Hague procedures. The Swiss Minister of Justice, which is about as high as you can go in the Swiss government, said that those procedures were available. And so had the ALJ simply accepted that, we could have gone forward. I guess the second question is, and I think we made this point as well, that one of the points of the consultation procedures is if you go government to government, the Swiss government can decide that, not an ALJ or the DC Circuit or any of these other people. The point of consultations is you let the Swiss decide the Swiss issues rather than having an ALJ decide the Swiss issues.
You never went,
But I thought that ultimately the ALJ made a finding that the commission, affirmed or adopted, that there wasn't really a reasonable fear of criminal prosecution pursuant to Article 2, or violation of Article 271, because the evidence that the ALJ had before it from the opinions of your Swiss counsel, et cetera, the instances where there had been criminal prosecution weren't anything close to these sorts of disclosures. It was, disclosing information to prosecutors and not parties to a case, et cetera. And so the ALJ found that you hadn't really demonstrated a real fear of criminal prosecution, and the commission adopted that finding. So it kind of makes all of this discussion about consultations and Hague, et cetera, irrelevant in their view. Isn't that the record that we have? And if that is the record, then where's the abuse of discretion in that?
Two answers, I guess, to that. First of all, the ALJ did purport to read, it was, I guess, the EFG case, the Southern District of New York case, as saying, well, this is all unnecessary because this EFG case says it's unnecessary. The commission did not adopt that ruling, didn't discuss any of it. The commission said that the procedures of Hague were unnecessary because of the Geneva Court's ruling, not because of the reasoning that the ALJ had about reading the Southern District case. So I think, first of all, it's just incorrect that the commission adopted that ruling. Second, we had evidence in the record from Swiss counsel. They specifically discussed the EFG case. They specifically discussed that. They discussed why that was not the proper reading of Swiss law. And that's, I think, JA 150, I think maybe is where we had that. I'm trying to,
Well,
or 250, whatever it is.
Going back to
we
Judge
just-
Pillard's question.
Yeah.
The ALJ disagreed with that, obviously. How are we supposed to review whether, the ALJ abused their discretion by disagreeing with what the advice or recommendation was from
Right.
your counsel?
or can I jump in and just
Sure.
pile on to that, which is, I actually think it's a little bit harder for you because it's not disagreeing with what they've said, but it doesn't meet your burden to show that you can't comply because of that exposure, which is a slightly different question. You have to persuade that you can't comply. And even if, ultimately your counsel might be right, she wasn't persuaded. She didn't feel like she had enough.
Right, and I think I think the answer to both those questions, I hope it's the same answer to both, is that the whole point of the consultation requirement is that she isn't in that position of deciding Swiss law and having to decide it. You aren't in the position of having to review her Swiss law determination, that you go to the Swiss for that. You either go through the Hague procedures, which, ultimately would have been successful, we found out when we went to the right office. But that if you were not accept that, you have a government-to-government consultation, and you go to the Swiss government, and the Swiss government decides what that's going to be. I think the whole problem we have here, I think all of the problems you're raising go away if you follow the consultation procedures. Because
I find this actually really, just as a practical matter, I've never done a case before under this, reviewing this commission
Sure.
and under this statute. But it sounds like what you're saying is that every time any Swiss person or entity is involved in civil litigation in, let's just say, the United States, because I know our discovery regime is distinctive compared to, let's say, civil law countries. Anytime discovery is sought, that you have to do Hague Convention or letters rogatory or some government-to-government diplomatic process in order for that case to move forward to summary judgment. Is that true? And if so, why are there not a lot of citations?
Okay, two answers, I guess, to that question. First of all, that was the question that was presented in the 1987 Supreme Court case. I think it was Eris's, Societe or Especial, whatever it is, some long foreign name. But in any event, and I think the Supreme Court, recognizing your concern, said, we're not going to say it's required in every case. We are going to say there's a comedy analysis that has to be done. They had a 5-factor comedy analysis, and that 5-factor comedy analysis is going to have to be done. That, I think, is what, and nothing like that was done in this case. So yes, certainly there is some power, in the federal court. They don't have to be bound by all of this. That's what the Supreme Court said, but they're supposed to at least give some kind of weight to it. Second, we're talking here about the Shipping Act, where there is a specific consultation requirement. And so that's the, that I think is the difference. In other words, I think the consultation requirement, and I think the Shipping Act of 1984, which put this in, was passed, I think, before the 87 law. But I think the Shipping Act really decides that issue that the Supreme Court said, no, you don't have to use it in every case. Under the Shipping Act, you do have to use it when it's alleged. They basically decided that case the other way statutorily. So Congress has made that decision. And I think it's because, we have it, it's an international regime. There's a long history to this too, because there was a lot of,
All right.
yeah, there's a long history to this too. There were blocking statutes that led to antitrust criminal prosecutions that led to all of it. But the answer is, under the Shipping Act regime, yes, that is the case. Now, maybe if there's frivolous allegations or something, but we felt we were far beyond frivolity here. We had this opinions of Swiss counsel were very carefully done and very carefully addressed what the ALJ ultimately cited and the commission did not adopt. If for anything else at this point, I very much appreciate the patience of the panel. Thank you.
All right, we'll hear now from the commission, from Mr. Summer.
Good morning. The first thing I'd like to talk about is that the commission did in fact rely on the district court cases that were just discussed, that the ALJ relied on in showing that Article 271 does not present a credible fear of criminal prosecution, where the sanction involved in the proceeding in the United States does not involve the potential for a criminal penalty, which was the case here, because it's administrative.
Concerned that there might be prosecution in Switzerland?
That's right. But the basis for the district court rulings that the ALJ identified and the commission also relied on was whether there was a potential for a criminal sanction in the United States or in the foreign nation. That's the way we read those cases. So I think that was something the commission also relied on. In addition to the lack of factual support for the claim, even though now we've heard about the documents in Switzerland, there's no specifically identified documents or materials responsive to the 14 categories of materials that the administrative law judge went through and identified where they had stopped producing or failed to produce any further materials. So the factual basis was not met here as well. And that, I think, dooms their claim, as it would under a Hague Evidence Convention claim, where the federal courts say you have to demonstrate a need for the use of these procedures rather than ordinary US civil discovery procedures. Here, they didn't make that showing. In fact,
Well, I
in
think
their-
they think they've made that showing in gross, that there is no page of what they have in Switzerland. Actually, I don't think it even matters whether it's in Switzerland. It could be in the US, could be in, who knows where, next door. And I think their position is once a governmentally empowered forum says you must produce, that they are in criminal jeopardy under 271 of Swiss law because Swiss sovereigns are the only ones who can say that another sovereign can transfer information. So I think they don't think it matters what information they are withholding.
That may be correct. Our understanding of 271 is that it applies to things produced from Switzerland or in any event from outside the United States. In this case, Mediterranean, the largest container shipping company in the world, has a massive US presence. They have more than 1,000 employees here. They have a number of ports and offices. And it's important to remember as well, the activity at issue was shipments from China to the West Coast of the United States. So it's true that, as I think Judge Pillard, you were referring to, why isn't this if this was really necessary, why isn't this a bigger thing? I mean, the Shipping Act of 1984 has been in place for more than 40 years, and yet there has been virtually none of this until the last couple of years. No claims like this that I'm aware of. Instead, parties like Mediterranean and other major carriers have been able to comply with their discovery requirements without the use of these procedures, at least relevant to US-bound or US-related ocean-bound shipping. So
Can you answer?
we,
Did you get what you wanted? I have four things I'd like to raise with you, if I can. I'd like to know whether, with respect to each one of these four things, they constituted the basis of the complaint under the act that was being pursued by the commission in this case. First is unfair or unjustly discriminatory practices. The second is undue or unreasonable preferences. The third is undue or unreasonable prejudice or disadvantage. Then unjust and unreasonable regulation and practices. Can you go through each one and tell me whether it is your understanding that with respect to each one of those form the basis for the complaint in this case under the Shipping Act? And if so, what section of the act are we talking about? First one was unfair or unjustly discriminatory practices.
yes, Your Honor. I believe those were all part of the claims that MCS, the complainant in the administrative case, made. And I believe you may be talking about section 41104A5 and 41104A9, because I believe, although I may have missed some of the phrases you had, I believe those include the language that you cited. I think those were two of the 5 claims that MCS made in the underlying matter. And so, yes, I think those were at issue. I also think it's important to note here, maybe if I can, that it would only be necessary to sustain jurisdiction and claim sufficiency as to one of the 5 claims that they made in order to sustain the decision.
I understand, given the long argument that we heard previously, I thought this was pretty straightforward, and I'd like to make it clear now, at least for the record, that these are matters that were clearly parts of the charges that were brought under the Shipping Act. And I just wanted to hear your position on it since there's been some discussion. These are, as you may recognize, precisely the matters that the commission cited in Cargo 1 in saying that these are matters that arise under the Shipping Act and clearly within the jurisdiction. And so if we have those claims here, we clearly have jurisdiction.
We think so, Your Honor. That's right. And for many other reasons as well, because there are the other claims, and some elements of those claims depend on in fact, explicitly relate to performance of service contracts. So it should be no surprise that there is an intertwining, as I believe Anchor Shipping put it, or an overlap with contract-related claims. Others, like 41102C, do not necessarily relate to a contract at all, but they're broader claims about the just and reasonable handling of cargo. There too, MCS made allegations, specific factual allegations that don't depend on a contract. They don't depend on a breach of contract. They went well beyond, and in fact, they didn't make a breach of contract claim, nor did they simply parrot elements of the Shipping Act. They made specific factual allegations about things, as Judge Wilkins pointed out, that are distinct from or peculiar to the Shipping Act.
Well,
Like the surcharge.
Let me hear your response to the argument made by your friend on the other side, which is that, like, if you look at paragraphs 98 and 100 of the verified amended complaint, where they say, you know, there's this widespread practicing of coercing the payment of these surcharges and forcing people to obtain space on the spot market. They say that ultimately those are contractual claims because the basis of the claim is that rather than honoring the service contract, you're forcing us to use these other avenues. So this is still a inherently contractual claim under Cargo 1. Why isn't that right?
I think it's not right, Your Honor, because the claim itself is, as I think you've noted, built on practices that go beyond. I mean, that's just not an element of a breach of contract claim, although those claims do vary by jurisdiction, and it would depend on an analysis of.
Is that the unreasonable preference and advantage?
That could be, Your Honor. I think
That's
here.
104A9, so that's clearly within the statute. I mean, some of these things are clearly going to emanate from what did you do under the contract? And you could end up having practices that the commission has said in Cargo 1 are within its jurisdiction, unfair and unjustly discriminatory practice. Well, that may start with what you failed to do under the contract. Doesn't make it inherently a contract claim. It makes it a Shipping Act claim. You failed to do what the Shipping Act said.
Yes, Your Honor. I think that's just right. And as far as evaluating practices, those practices include relations that Mediterranean may have had with other shippers, and that's the basis for the discovery about matters that go beyond the specific contracts and relationships involved here, because under the statute, that's part of the analysis.
I have a question about sort of the practicalities and I guess what is effectively claim splitting. If I thought I heard you say that it's only necessary to sustain jurisdiction with respect to one count to sustain the ALJ's jurisdiction to hear the case. And I read Cargo 1 otherwise, that it's looking claim by claim and saying, well, the claim under what is now the 40502F, you know, no, the claim that is under the provision that says breach of contract is a breach of the statute, that can't be heard by the commission, even if it's packaged in a complaint with other claims that can. But I thought I heard you say otherwise. And the whole thing seems odd to me because it seems like in many cases you'd have, therefore, two different proceedings.
Your Honor, I don't think we read it that way. I think in this case, there are 5 distinct claims, even though they may have some things in common, under the 5 distinct provisions of the relevant part of the Act. And that's the 4 under Section 41104 and the 1 under Section 41102.
And this, I think it's the
so-
41102, count 2, no, 41104A2A, which is alleging that Mediterranean provided service not in accordance with the service contracts. You know, Congress is basically writing contract violations into the statute in that provision, and then Cargo 1 comes along and seems to say, no, if it's in effect really just a contract claim, it's out, And what's your position on a case that includes, put this case aside because there's merits arguments about what is and isn't a valid claim. But if there are valid claims under the provisions that Judge Edwards is talking about unreasonable refusal to deal, let's say, or undue or unreasonable advantage, apart from a breach of contract, those are under the commission's jurisdiction. I don't hear anybody, at least in general, to be disputing that. But do you dispute that a claim under 41104A2A is exactly the current provision that the claim in Cargo 1 that was held not to be under the commission's jurisdiction is the analog to that very claim?
I do believe that is the basic claim that was that one of the 5 claims that is one that was being discussed.
And I thought what happened in Cargo 1 was they said, we can't hear that claim, and they remanded other claims. And I guess the question is, if that's right, why does the commission sustain the ALJ's decision that it could hear that claim, not purporting to apply Cargo 1, but nonetheless saying, well, this is under the act?
I think there is room to read it a little more broadly, Your Honor. I mean, what it says specifically is provide service in the line of trade that is not in accord with rates, charges, and so on in a service contract entered into under the chapter and filed with the commission. So I understand the idea that that reaches claims where the contract hasn't been properly filed. But I think there is room to read it more broadly. There may be some tension there with Cargo 1, but I think the idea was that this is basically at the motion to dismiss stage, and it did seem potentially viable.
I'm not following that. How is it different?
I think it's different in that it's not literally a breach of contract claim. It's providing service in the line of trade. It's not in accord with the contract. Granted, there's an enormous overlap there, but I think that was the basis for the commission to uphold that.
Provide service in the line of trade that's not in accordance with the terms of a service contract entered into under Chapter 405. And I think that is the exact provision that was at issue. The precursor of that provision was what was at issue in Cargo 1. And I didn't see, with respect to that, any engagement by the ALJ or the commission. I mean, it cites Cargo 1, but it doesn't engage with the reasoning of Cargo 1 that those kinds of claims are not under the jurisdiction.
Your Honor, I think you're probably correct that there was not a substantial engagement with that issue.
Or really, to be fair, any engagement with that issue?
But I think, again, looking at all the claims, all 5 claims, in this case, if any of them are troubling, I do think that even one, such as 41102C, is sufficient to sustain the decision here.
But
Why
how
is
is that?
that?
I'm sorry. How is that the case if the default judgment is entered as a sanction and the relief is based on all 5 counts? But what if the ALJ was wrong to find, 2 of the counts within the jurisdiction of the commission? Wouldn't the relief or the remedy that the ALJ entered need to be set aside so that the ALJ could reconsider the relief based on the counts that are properly before it?
Your Honor, I think that the basis for the default was conduct that would be properly sanctioned, even if only one claim had been made. That's the basis for the basic decision for default. If you're referring to the reparations, I think that's appropriately upheld even based on one claim, because each of these claims is based, as I understand it, on the entire course of conduct alleged. So I'm not aware of a clean division where you could say, oh, well, claim 1 was only about 1/5 of the activity in question. In fact, these are overlapping claims. And my understanding is, for example, count 1 related to the entire course of conduct alleged. So not only would it support entry of default, just that one, but also the reparations awarded, which go to the overall conduct complained of, the course of conduct. So I think that's why each of them encompasses the whole thing, and each would be sufficient to sustain the default, because you can't engage in the kind of activity and really a lack of respect for the orders of an administrative law judge without some sort of consequence. And the agency here concluded, after Mediterranean had been given at least 3 chances to comply, that those orders had to mean something.
So on my question about claim splitting, do you disagree with the way Cargo 1 treated the contract claim, effectively contract claim under A2A and the discrimination or inconsistent treatment claims? When I read Cargo 1, what I take away from it is that the same plaintiff would have to go to a court with a contract claim and go to the commission with the statutory claims. Is that your understanding?
Yes,
How that's supposed to go?
Yes, Your Honor. And I think that does commonly happen. I believe it's happened in this case, or at least in arbitration, which is proceeding.
And
But-
then is there offsetting of overlapping relief? You've also just asserted that the relief is 100%
Well, with
the
regard to
same
the,
under all the different claims.
right, Your Honor.
And therefore, whoever the arbitration yields relief, they're not going to get double.
I think it would be appropriate for each proceeding to take account. I mean, if you're looking at contract damages or reparations under our statute, I do think it would be appropriate, if the idea is to make a party whole, a compensatory approach. I do think it would be appropriate, whether for the commission or for some outside tribunal, to take account of the extent to which a party may have already
Recover.
been made whole.
And
Yes,
is there
so.
claim preclusion? So if the plaintiff wins let's say if the plaintiff loses before the commission, does that prevent any arbitration from going forward?
I would not think so, Your Honor, unless, that's an interesting question.
So
I guess I don't know.
Effectively gets 2 bites at the same apple. The plaintiff loses in arbitration. Is that preclusive of the commission?
I would doubt it, Your Honor, and I don't think
Does not come up?
it's not, I'm not aware of it. It's at least, it's not the same apple, right? The breach of contract apple is different from the Shipping Act statutory claim orange.
Although you just
There
made-
may be, or
You just
perhaps there,
powerfully argued that they're actually different packaging for the same ball of wax. And that makes sense in civil procedure terms. You have one transaction occurrence. You can seek to recover for the harm you suffered from it under a contract theory. You can seek to recover for the harm you suffered as a result of this transaction occurrence under a undue discrimination theory or et cetera. But in the real world, the thing that happened and the thing that harmed you is one transaction or occurrence, which is why it surprises me. I mean, I'm not sure that if I were the commission, I would decide Cargo 1 the way it was decided, in part for this reason.
I think that there are distinct claims, and it may be that when you get to the damages stage, accounting would have to be made for what might have happened in another setting. But I don't think there'd be preclusive effect for distinct claims, one being.
Typically in the courts, there's preclusive effect, no matter how you name the claims.
Not these
You look at
claims.
the underlying transaction or occurrence. Could you, and then there are these issues of, well, could you have raised a claim in that form? And if you can't, then sometimes that's split up. But it's a very strange system to embrace. It tends not to be particularly functional or efficient.
Your Honor, I do think that there is an approach or a test that's emerged from Cargo One and Anchor Shipping. And I would direct the court's attention especially to Anchor Shipping, because I do think that has a lot in common with this case, is the ALJ relied to a significant extent on the factual and legal similarities with Anchor Shipping, which is 6 years later than Cargo One. But I do think that the analysis about whether claims have elements that are peculiar to the Shipping Act or distinct from breach of contract claims is the prevailing analysis and the one that the agency has applied. So that I think is the one that was applied here, and that's appropriately applied.
But was it appropriately applied? Here, are there any complaints that are alleging a violation of the act, citing a provision of the act, that the commission nonetheless cannot hear because they are inherently breach of contract? As long as the act is cited I mean, that seemed to be the view of the commission and the ALJ in this case.
Your Honor, I don't think it was just citing. I think it was, of course, alleging a violation of a specific part of the act, citing that, not saying it's a breach of contract, and here are the elements of a breach of contract. So, of course, starting with that. But what happened here, I think that where that line is may vary in different cases, but what happened here is the claimant went far beyond merely reciting and stopping. They made specific factual allegations about practices and activities that would not really be elements of a breach of contract claim, as I understand it. They go beyond it. They're peculiar to the act, like coercing surcharges, like some of the other elements that Judge Wilkins read from that part of the complaint. So I think in this case, wherever that line is, and words like inherently perhaps are not always, as clear as they might be. But in this case, where there were specific allegations in MCS's complaint, which go beyond contract claims, go beyond merely parroting elements of the act, I think it was appropriate to find jurisdiction for those claims.
I'm just, again, circling back to count one, violation of 41104A2, the conduct constitutes provision of service not in accordance with the rules and practices contained in the respective service contract. Is that something other than you acted in a way not consistent with the terms of the contract?
I think it can be read as creating some space. I would
Some
agree.
space between what and
that
what?
Between a breach of contract claim, again, which is very, I think, dependent on a specific jurisdiction. So in the abstract, a breach of contract claim is analyzed somewhat differently in different jurisdictions. But I think there is potentially some room in that language. I mean, that's not just, contract law is very specific about
I'm
what
not
constitutes.
following. I need maybe a concrete example, because if you say to me, I'm going to sue this carrier for providing service not in accordance with the service contract I entered into with it, and that is a violation of 41104A2, that is, as far as I can tell, and as I said, I'm no specialist in the Federal Maritime Commission statute or decisions. As far as I can tell, that is the same claim that the commission in Cargo One said, no, that is excluded under subsection F of 40502.
I think.
Numbered differently then.
I'm sorry?
It was numbered differently at the time of Cargo One.
That's right. There was a recodification. I believe it is essentially the same claim. And so I think in this case, there was a view that there was room for a claim based on the allegations in the case. But I would agree that there's a significant overlap there, obviously, between that language and a breach of contract claim. So.
All right, I'm gonna give you one chance to explain to me. I really don't want to just hassle you about it, but what is it about it that goes beyond just a contract claim? What is it about how that's stated?
Well, I think service in the line of trade implies a broader course of conduct than simply breaching a contract in a sort of defined way. That's one basis. And so if your conduct is not consistent with the elements listed in the service contract, I think that's a potential distinction.
Let me, to add on to this question, to see whether or not you think this is an answer or not to my colleague. On page 36 in Cargo 1, this is why I started with you. There's a whole lot of debate we've had today about the reach of Cargo 1. But this is the page where the commission is very clear in saying what is and is not covered by its decision and making it very clear where the commission has jurisdiction. Unfair or unjustly discriminatory practices. We've been around that. They say that's clearly an area here, and that's part of what this complaint is about. Undue or unreasonable preferences. That's clearly been covered today. Undue or unreasonable prejudice or disadvantage. That's clearly been covered by what we've covered today. And then there's one, regulations and practices. What does a regulation and practice mean? Now, is that answering what Judge Pillard, because that's one of the things that commission says is covered.
Your Honor, I think it is possible to interpret that as having a relationship or overlap with providing service. Providing service implies a more general.
In other words, if we look to see, and you're just basically doing bad things all over the place, we can catch you this way too? I'm being serious. Is that what we're talking about?
No,
You just have a
certainly
routine of
we're
bad
only
practice.
we're only trying to enforce the law as written, not looking to find
No,
bad things.
this is the
But-
commission's take on it. So I'm trying to get your understanding as to what they mean when they include, I'm sorry, it's not unreasonable prejudice and disadvantage, it's reasonable regulations and practices. That's the last category in this list where they're saying these are all things that are covered and it's within our jurisdiction. Reasonable regulations and practice. Is there something there that does some work for you in answering to what Judge Pillard is saying? Asking?
I may not be completely following what you're saying.
Can you look at the passage? Do you see Cargo 1?
I don't actually have that case right with me, Your Honor. But I think that wasn't intended, I think, to be an exclusive list of things the commission has jurisdiction over.
No, I know we're trying to
So-
at least get to a point where we agree on some things. The one thing we ought to be able to agree on is what emanates from this list. This is the commission's list in Cargo 1, which has been the subject of 5 hours of debate today. And they list 5 things here. All I want to know is what you think they meant, the last thing they list, and just and reasonable regulations and practices.
I think that, Your Honor, that was likely a reference to 41102C, which talks about the need to have common carriers essentially must establish and observe just and reasonable regulations and practices. So I think it's a reference to what is currently, although perhaps not at the time of that decision, what is currently at 41102C. So I think there the commission was going through a lot of the same provisions at issue in this case and saying there certainly is jurisdiction for that claim, 41102C, and then you also have described language from 41104A5 and 9. I think some of the other phrases you used were what it currently
Commission
appears.
use, I didn't use them. I'm just citing them. And I'm trying to address
Right.
the other side's suggestion that none of what's here is subject to commission jurisdiction, which seems to be just patently wrong in light of what the commission says on page 36 of its own opinion. They listed the only category I can't make complete sense of is the very last category, and just and reasonable regulations and practices. And I was wondering if you knew what they might have meant by that. The rest are self-evident, and they seem to be all covered in this case.
Yes, Your Honor, and I do think that language that you're asking about is cited is directly in 41102C currently. So I think I think that may be the answer to that.
I have a question about the commission's first order suggested that Mediterranean had shown bad faith by not immediately appealing the ALJ's discovery orders. But didn't the commission's order elsewhere acknowledge that Mediterranean had no right to appeal a non-final ruling like a discovery ruling?
I hope the commission didn't say one, I don't think the commission said one failure to appeal was by itself bad faith. I do
No,
think
but they cited it as evidence of bad faith, and I was stunned by that.
I think they do have a right to seek appeal, and here they had 3 chances to at least seek to appeal the interim orders. Under 46 CFR 502.221, you can ask an ALJ to appeal a non-final order, and if you can make a showing, then that does happen. And here, I think they would have had a fairly strong argument. If they genuinely believed that they were prevented from complying by a foreign blocking statute, I think that would be a pretty strong argument that the commission should have heard.
So it's effectively like seeking a certificate of appealability in court. Like you have to get permission to do it.
You do have to get permission, but I don't think it's like seeking cert. I think it's something that would be likely available in a case like this if they could demonstrate. I think they would have to make some demonstration. I can't predict how it would have gone. Some factual and legal demonstration that they did in fact face that kind of peril, and they wanted to respect the agency. They didn't want to simply ignore the agency's orders 3 times in a row. They wanted to give the agency a chance to determine this issue, so they could have sought to appeal that under that
Although
regulatory
it could have
provision.
been seen as procedurally obstructive to not wait until final order and appeal then, which is the ordinary course when one is in a adversary dispute resolution form. Is it the commission's position that seeking to employ the Hague Convention is a sign of bad faith supporting default judgment?
Not in isolation, Your Honor. But I think if you look at how federal courts evaluate requests to proceed under the convention, you do have to make a showing that it's necessary. And that showing wasn't made here. I mean, if you look at the cases, the Illuminati networks and Al-Fata cases that the ALJ cited, there has to be some showing of necessity with specificity, specific documents or categories of documents that you can't produce, not a general refusal to proceed in 14 categories sustained over 3 different orders.
And so that entails, I think, and we can hear from Mr. Longstreth on rebuttal, but I think that entails disagreeing with his way more categorical position, which is that it doesn't matter the nature of the information that's being sought. If it's being sought by a governmental enforcer from a foreign country, that it cannot be produced without resorting to Hague. And I don't see any authority about Swiss law in the record other than Mediterranean's own authority. So I don't see any authority about Swiss law in the record supporting a more granular, nuanced view about what would require resort to Hague.
I think here, the party doing the seeking is the administrative complaint at MCS. The commission is in the nature of a court, just like all these other cases, like the 2 I just mentioned. Those are courts deciding private disputes, as I understand it, where one party was seeking discovery. And it's true that private party complaint discovery could potentially entail the need to resort to those procedures. But I understand that the requesting party is not like a prosecuting authority. It's like in the nature of a judicial proceeding.
It's in the nature of a judicial proceeding. And the distinction that I hear Mr. Longstreth making is pre or extra judicial sharing of information versus judicially required. And I mean, consider that ALJ's signature and seal were on the Hague request.
Yes, that's right. But again, I think that's also true of the cases where the federal cases that say you have to show that it's necessary in order to push out of the ordinary U.S. civil discovery procedure.
And
here,
Societe, the Supreme Court's decision, Societe says if there's a risk of that you'll be criminally prosecuted, that is a component of whether it's necessary.
which
How can we say,
which wasn't the case here. So,
they're saying, yeah, that we're
criminal,
open to criminal
I see.
prosecution under 271. And
Yes, right. And we're saying we don't think they demonstrated that risk, and we also don't think they've demonstrated a factual need under, certainly not at the time they were before the commission, before the ALJ. And I think that's part of the
they haven't
analysis as
demonstrated
well.
a factual need.
Yeah, they haven't demonstrated with specificity what materials they can't provide, which apparently were providable for 40 years by major carriers in these proceedings, where we never saw this kind of argument. They haven't demonstrated,
From Swiss defendants?
in general, from Swiss, from anyone.
I mean, the reason I ask is because Swiss has information privacy laws that are, second
Understood.
to none.
Understood.
It's part
Understood.
of their UNESCO World Heritage.
But in general, we haven't seen that. So that's, and I think they needed to do more on that in order to justify it under the procedure that federal courts follow. So.
Yeah, I think I found the answer. I'm sorry, I pushed hard and didn't look carefully. The reference, I'm just really trying to tie this to Cargo 1 because there's certain things I got to get clear in my mind. The commission gave us an answer on page 36 as to what's clearly within their jurisdiction. So whatever confusion there is from the prior pages is washed away. And I asked you about the last category, and that is 41102C, common carrier, marine operator, or ocean transportation intermediary may not fail to establish, observe, and enforce just and reasonable regulations and practices relating to or connected with receiving, handling, storing, or delivering property. And I gather that's among the complaints in this case or not?
Yes, that's right, Your Honor. That's right.
So everything that's listed in Cargo 1 that the commission has clearly said is within their jurisdiction is among the complaints that have been raised against the other side. Is that right?
I believe that's correct, Your Honor.
Right, thank you.
Mr. Little. Oh, an interview.
All right, Mr. Reynolds for MCS.
Good morning. Thank you. May it please the court, Matthew Reynolds for the intervener and the complainant below, MCS Industries Incorporated. MSC's challenge here is premised on an intentional misunderstanding and cabining of the causes of action that MCS Industries brought in its original complaint and its amended complaint in this administrative proceeding. And it's interesting because that same cabining, that same misinterpretation of our claims is what drove the very discovery deficiencies that led to the order granting our motion to compel and eventually led to the default in this case. MSC clearly would very much like our causes of action to be nothing more than breach of contract claims. They are not. One of the reasons I know they are not is that I am currently litigating breach of contract counterclaims against MSC in a separate arbitration that, as has been discussed in the papers, is proceeding in parallel with this proceeding.
I'm sorry to interrupt you. Can I
Sure.
ask you on the discovery issues? We have very broad, so far, very broad positions, pro and con. Can you give me your most compelling points that of if you could only have 3 categories of information that you think you're entitled to, can you give me a little bit of granularity with respect to what are they and what claims do they go to support?
Absolutely, Your Honor. I think that the main cause of action that is at issue with respect to these discovery deficiencies is the first count of our complaint, which was under 46 U.S. Code 41102C. That is the unjust and unreasonable practices claim. As counsel for the FMC has indicated, that claim is the one that I think most explicitly and clearly goes far beyond the sort of plain vanilla breach of contract concepts that MSC's counsel has discussed. By regulation, claims under 41102C are held to a heightened pleading standard, and they are held to a standard where you have to establish a practice that occurs over time. It can't just be a claim that one carrier did something wrong once to one complaining shipper. It's a pattern or practice standard. And so for that reason, many of the discovery requests that MSC refused to comply with went to evidence and documents, communications, and data that would go to prove our 41102C C claim under that heightened pleading standard. Under that standard that almost by definition would require more than just discovery about MSC's specific interactions with MSCS Industries in isolation. So I think that would be the strongest claim.
It's not actually a heightened pleading standard. We're beyond pleadings. This is about evidence. You're saying it's a challenging item of proof or element of proof.
Yes, Your Honor, that is correct. The FMC's regulations have imposed a heightened burden of proof for claims of that nature, specifically to separate them from sort of the garden variety type breach of contract claims that we've been talking about earlier today. And so for that reason, many of these categories of discovery requests sought data and information, not just about MSC's dealings with MCS Industries during the relevant time period, but also its dealings with other shippers, both on a spot market basis and on the basis of their service contracts, because that evidence would have been necessary for us to meet that heightened burden to prove count one of the complaint.
And the particular evidence?
The particular evidence would have been information about peak season surcharges, for example, that were imposed on a divergent basis among different shippers during this time period. I will also note, Your Honor, with regard to the earlier question about count two of our complaint, Your Honor asked if there were any ways in which our count two, which is closest to sort of a breach of contract concept, would be distinct from that. The peak season surcharges, I think, are a good example of that. Those surcharges, as alleged in our complaint, were extra contractual charges that MSC sought to coerce from MCS Industries in order to carry its cargo. That would be an example of conduct in the course of providing service in the liner trade that is not consistent with the terms of the service contract.
And I know you briefed this, but doesn't your contract with Mediterranean allow them to request surcharges and void the contract if you refuse to pay them? Your view is they wanted to charge surcharges but they didn't want to have to void the contract?
It allows them to request it, but it requires mutual agreement on the surcharges in order for them to be charged. And so I'm giving that as an example of how that extra contractual charge would take this outside of the pure breach of contract concept that we're talking about and put it within the provision of 41104A that Your Honor asked about.
You agreed to a second Hague Convention letter. How can you now defend that having asked for that and insisted on it, but Mediterranean's insistence on that is somehow unjustified delay supporting default?
I think, Your Honor, that the ALJ was not wrong to accommodate MSC's request for Hague Convention proceedings, but as the ALJ, I think, correctly determined, those proceedings were not in fact necessary. There was, of course, no risk of criminal jeopardy in this administrative proceeding. And so relying on federal case law, relying on authority that the ALJ appropriately looks to, the ALJ concluded that it was unnecessary. And so although we were perfectly happy to go along with their recommendation, when it was determined by the ALJ that that procedure was unnecessary, of course, our view was they should produce discovery. That was our view from the very beginning of the case, that they should simply produce the discovery.
All right.
Thank you, Your Honor.
Thank you. You want the time reserved, Mr. Longstreth? You have 3 minutes.
Try not to take all. Just some very quick points. First of all, on the A2A claim, the breach of contract claim, the point I'd like to make there is, and I think even my friend Mr. Reynolds says that's closest to breach of contract. It's really indistinguishable from a breach of contract. But the point I wanted to make was that Your Honor is 100% right. The ALJ did not engage with that at all, even though Cargo 1 says that that's a claim that should be presumptively outside the commission's jurisdiction. The ALJ made no distinction between that claim and the discrimination claims and the others they're talking about. So we think at the very least, there's just a complete failure of the ALJ to explain how she was applying cargo one in this case. It may very well be that if the commission were to unpack this and look at the allegations, they would agree with Judge Edwards that these fall within. I think if they listen to this argument, the commission will probably come out that way, as I hear it, if that's the way the panel comes out. But the point is, the commission has to make that decision. Judge
Right, so-
Edwards can't make that
So we remand to
decision.
the commission to do it.
I would think you'd have to, because they didn't discuss A2 at all. And A2 is, as I was trying to say, and really apologize for being impatient on that, but A2 is different from these other claims because A2 was distinguished in cargo one itself as
Okay.
something that's going to be outside their jurisdiction.
And do you agree with Mr. Summers that claim splitting is just par for the course in these shipping act cases?
It is, and this is one of the reasons why the jurisdictional limitations have to be enforced, because otherwise, we've got a case now for another client. We're in 3 different forums, and they came to the FMC a year and a half after filing a breach of contract claim and after filing an arbitration claim,
I would think
because
that's the
they're
reason
open
that
for
the jurisdictional
business.
Limitations, you were allowed to interrupt you, you're just not allowed to.
I'm sorry, believe
The
me.
jurisdictional limitation in cargo one doesn't make any sense. It's
Yeah.
Either you're, do the whole thing here, and then if everybody's satisfied, done,
Well-
why have a court case?
Right. At the very least, I think they have to be serious about imposing and looking at the complaint to see what's really at issue here. So we're not dragged to 3 different forums. And they did not do that here. They didn't even try to
But
look
let
at
me-
whether
let me
this was
ask- let me
essentially
ask you this.
contractual. Yeah.
The way that your brief argues, at least in the opening brief, you say that there's no jurisdiction over any of the 5.
Right.
I don't see where you make the argument that if there was jurisdiction over one, but the other 4, there was not jurisdiction, you still have to remand. I don't see that argument in your brief. And we do, have a harmless error rule even in administrative cases as with everything else. So I'm trying to understand if we were to conclude that the commission perhaps got the analysis wrong as to 1 or more counts, but they got the analysis correct as to at least 1, why isn't that error harmless here?
I think with respect to the issue we're just talking about here, the error that's most obvious with respect to A2, where the commission actually said these are usually not in our jurisdiction and the ALJ didn't discuss it at all, also applies to the other claims as well, because she likewise did not discuss those. Now, as I said, it may very well be that those are harder questions, but they're and Judge Edwards actually thinks they're easy questions, but whatever they are, they're questions the commission did not address. And it didn't address them for any of the claims. It just said
But my
state.
question to you is
Yeah.
if I disagree with that,
Okay.
and I think that they did address it maybe as to count 1, but I agree with you that they didn't address it as to counts 2 through 5. What should I do?
Well, I think you have to look and see whether the commission would have. I think one of the reasons we didn't talk about claim splitting is the commission didn't talk about that. The commission didn't say, well, we would do this. So Mr. Summers is saying, well, if we lose one claim, we lose them all. The commission didn't say that. It just defaulted us generally. So I'm not sure that would really be an issue. One thing I did want to say with respect to Judge Pillard's question, when she's trying to unpack what discovery went to what issue and what didn't, again, something the ALJ made no effort to do. The example that Mr. Reynolds gave was practices. Well, we can't show a practice without asking for discovery about every other shipper you dealt with. And I think that's a good example of the abuse of discretion, which is that there are plenty of sanctions in default other than just losing. And one sanction here, potential sanction here on that would have been, okay, you can't challenge that it was a practice. We'll show it in our case because we think they can't show it in their case. So, we don't have a practice if they can't show it in their case. But we could say that could be one of the things you could do as a sanction. Say, look, if you're really getting into it, okay, if you show it happened in your case, because you haven't provided this other evidence, you can't challenge that it wasn't a practice. That element is taken as conceded. And that's the kind of analysis, you generally expect in a default, okay, because we did produce a lot of evidence, okay, a lot of discovery voluntarily, and we were treated as if we had produced none. You go back and look, well, what did they produce? What didn't they produce? How does that tie to the claims?
Speaking as a newcomer to the case, I am really baffled why you're fighting the production of any of the supplemental information. I just don't understand
that
as a
gets-
business decision. I don't understand what you're seeking to get out of this case.
That gets,
And I think that may be not far from where some of the decision makers in the commission.
okay, and that's the third point I wanted to make, and then
Right.
I'll sit down. So I'm glad we're on the same page. The way that I know, and I can't get in too far into privilege discussion, but the way I know we looked at it and the way Swiss Council looked at it is that the act of production from Switzerland, in other words, they're directing it. Our legal offices in Switzerland, our advice on this is from Switzerland. So if we direct that production from Switzerland, it doesn't really matter if, well, maybe we could access the document from this or there. And they did. I mean, I understand that the commission was skeptical, and I understand my friends on the other side are skeptical, but they were, maybe there's a small risk of criminal prosecution, but, general counsel's not going to tell his, boss, sure, it's only a small risk, particularly when there's a procedure available that removes the risk.
And was I correctly characterizing your position in questioning the other counsel today, that your position is that it's any information can't be provided from Switzerland because it's under the compulsion of an actor of a foreign government?
Right, it's under the compulsion of an actor and decisions maker in Switzerland are the ones who have to decide whether to bow to that.
This is just speaking for me. We have not
I understand.
conferred, but I would urge you to ask your client and or your Swiss co-counsel the question that I had about whether you could voluntarily
Right.
do anything.
And others who get said that, we've got this compulsion order, but could we do it under
Could you
protest?
sidestep and say, we're not doing it because of that. We want to bring this case to some kind of resolution.
Is that
But
something you want,
that's-
is that something you want us to file supplemental advice on, or is that just for
No,
us?
it's
Okay,
literally just my
just your thought.
free reaction. And it doesn't speak for the court.
Nope. I understand. Thank you very much. Again, I appreciate very much, and I apologize for any heat of.
Thank you all. Case is submitted.
This honorable court has now adjourned the Monday before Saturday.